Here's what you wrote last week. You said that the last week has been a decade of legal news. And in the last few days, look, we have the judge in the Stormy Daniels hush money case granting Trump a hearing on his motion to dismiss the charges. And the long shadow now over the case is coming from the U.S. attorney at SDNY. So you are a former U.S. attorney. What do you think is happening here? And is it a serious threat to this case being able to go forward?
So I think the short answer is we don't know yet, and that's why the judge has scheduled this hearing on the 25th. He wants to determine whether anyone, and by anyone we mean the Manhattan DA's office, who has brought this case against Trump, has failed to uphold their obligations to turn over discovery to Donald Trump. It's complicated because of the involvement of the U.S. Attorney's Office. Trump sent them a subpoena. They have turned over more than 100,000 pages of documents, which sounds like a lot until you understand that lawyers use software to make this process of determining which of those documents are relevant a relatively quick task. But the judge will want to see whether the Manhattan DA's office played any role in not turning over documents or whether this is simply a squabble between Trump and the U.S. Attorney's Office.
Okay, now, hang on a second. You said they have software that can make this a relatively quick task. It has been a year of trying to get these documents. Why a year?
Yeah, I'm not sure if that's an accurate characterization, Alex. The Manhattan DA asked the U.S. attorney to turn over some set of documents. We don't know exactly what, and they provided those to the Trump people months ago. Instead of going back to the Manhattan DA and asking for more, which is what you would expect if a defendant thought that they were entitled to information they didn't get, the Trump lawyers seem to have sent a subpoena directly to the U.S. Attorney's Office. There are a lot of restrictions on U.S. attorneys' offices turning documents over to a defendant in a case that they're not involved in under a set of regulations called the TUI regs. And the Justice Department indicated that to Trump. There were some delays in turning over documents, which the Trump lawyers agreed to, by the way. And ultimately, we've seen this rather recent development where the U.S. Attorney's Office has given documents directly to the Trump lawyers at their request.
Thank you for that answer, because now we don't have to ask that question again. I appreciate that. Let's talk about AP, which is out with a new look at Judge Juan Marchand, who is handling the hush money case. Trump has called him a Trump-hating judge. He says he's received dozens of threats after that, but added, quote, "There's no agenda here." So what do you think is going on behind the scenes? What are you expecting at this hearing, 8 days from now?
So this judge, by all accounts, is straight up. And I think that we're seeing that here. He's a professional. He calls the balls and strikes. He doesn't weigh in on behalf of either party. And I think it's instructive that he's asked both of the parties to provide him with their timeline for how discovery proceeded so he can make an independent decision about whether anyone was at fault, and if so, who. This is the kind of judge who has good control of his courtroom. He won't entertain theatrics from Trump. He won't let the prosecution get away with riding roughshod over a defendant's rights. He, I think, is the right kind of judge for this sort of a case.
Okay, good to know. Let's move to the Fulton County case. Judge McAfee ruling that Fani Willis is not disqualified, but he still issued that ultimatum that either she withdraw herself or her lead prosecutor from the trial, and Nathan Wade has since resigned. You think Judge McAfee overreached in this case. Why?
Yeah, so it's a very interesting situation. Georgia law is clear, and it says that there's only a conflict of interest that requires disqualification if there's a financial conflict of interest. The burden of proving that financial conflict of interest is on the defendants in this situation, and they completely failed to establish that. Even if you give them the best inferences on their evidence, there's just no financial incentive here. But the judge was concerned about what he called an appearance of impropriety in this situation. And so he required that Nathan Wade resign for Fani Willis to continue on the case. You know, that goes beyond what the law strictly requires. This is a judge, though, who is protecting his record on appeal. He had this full-blown evidentiary hearing, which was painful for Willis and certainly pried into her personal life more than was strictly necessary. On the other hand, it is valuable in this limited sense. there is every basis for the Court of Appeals to decline to hear this matter on appeal, even if the judge would issue a certificate of appealability. Under Georgia law, he's got 10 days to do that. I think that that's a week from Monday. And I'm not entirely sure that he will agree that there should be an interlocutory appeal on this matter, just because the facts are so clear and because he's taken these steps, which in some ways I think are overreaching, but that clarify the issue.
Okay, Joyce Vance, as always, it's an education and clarification and much appreciated. Thank you. So you can feel the frustration from Donald Trump critics. After a wild week, is there a chance any of his trials will be completed or even start before the election? We've got some answers.